Hey everybody, John Skiba here from the Consumer Warrior YouTube channel. In this video, I'm going to talk about what happens if you take your debt collection case to trial and you lose, or summary judgment's granted, or somehow you end up with a ruling that is not in your favor from the court. We're going to talk about whether you should appeal that judgment, and if so, what the process is for doing it. But if this is your first time here to my YouTube channel, please click subscribe, check that little bell, that way you'll be notified each and every week when I put out new videos that'll help you deal with your serious debt problem. All right, let's talk about the appeal process in debt collection lawsuits. Something can always go wrong. If you ever meet an attorney that says that they've won all their cases, they are lying to you. Even the best of the best, there are factual situations and sometimes just bad rulings from the court that could result in a ruling against you in your debt collection lawsuit. So first I want to talk about what the process is for taking an appeal. But the second question I want to address is probably more importantly whether you should or not, and really what the underlying process is for the appeal. So the first thing is the process for actually taking the appeal. It's important to note that once a judgment is entered against you, once the court rules against you, signs off on that judgment, the clock is ticking for you to file what's called a notice of appeal with the court that's going to hear the appeal. Now, you need to look at the rules of civil procedure in your jurisdiction and even the particular court within your jurisdiction to make sure you know what that deadline is. Most courts are extremely strict when it comes to the notice of appeal. If you're even 1 day late, then you'll waive your right to appeal forever. In places like Arizona where I practice, different courts even have different appeal periods. So, for instance, the justice court system, which deals with a lot of debt collection lawsuits under $10,000, you only have 14 days from the day that the judge signs that judgment to file your notice of appeal with the court. If you don't do it, you're done. The judgment is final. However, if you're in the Superior Court in Arizona, which deals with judgments over $10,000, you'll have 30 days to file that notice of appeal with the court so that the Court of Appeals can hear it. But if you're even 1 day late, then you're done. You're not going to be able to appeal your case. Now let's talk about the second question of whether you should actually appeal your case. It's important to understand when an appeal is filed, the court that's going to hear it, which is a different court, does not retry the case. There's no new trial. They don't have new evidence come in. There's no witnesses testifying, none of that. What they're looking to do is look if the underlying court, if the judge that sat in on the trial, if that judge made the right decision. And not only that, it's not whether just that they made the right decision, it's whether they abused their discretion. Now that's a pretty broad standard because I've had appellate judges tell me, look, I may not have ruled that way if I were the judge sitting in on the case, but the judge's ruling isn't so far outside the bound of what's acceptable for judges that we're going to overturn it. So you need to really look at why the judge made the ruling that they did, and it's probably, particularly if you're representing yourself, this is a good time to talk to an attorney and get at least a consultation and opinion on what they think about filing the notice of appeal and going through the appeal process. The appeal process is generally very lengthy. In Arizona, even in a small case, it can take a year, sometimes even more, before you're going to get some type of resolution to it. If you're hiring an attorney, there's legal fees involved, there's additional court costs. And if you lose the appeal, then the collector, the junk debt buyer or the creditor, they may be able to ask the Court of Appeals or the appellate court that's hearing the case to add additional fees onto the underlying judgment. So you got to be really careful which cases you choose to appeal and have a good understanding of why it is the court came to the ruling that they did. So hopefully that helps. Hopefully you don't get a bad ruling and the whole thing gets taken care of way before that. But if you do have the right to appeal these cases. The real question is, should you? If you have any questions, or if you're in the state of Arizona, I do offer a free consultation on these types of cases. You'll find my contact information below. Thanks for watching today.